Welcome, everybody, to our afternoon sessions. Hope you all had a good lunch. This is our third panel of the day, Strategic Litigation to Promote Human Rights and Environmental Protection. I'm going to do a little sort of very brief stage setting. I'm going to introduce the panelists, and then we'll hear from each of them in turn, and then we'll end the panel with some Q&A. So make sure to keep track of your questions for the end. So climate cases are here, they're everywhere, and they're here to stay. The Sabin Center for Climate Change Law at Columbia University maintains a database of climate litigation, and they track climate cases all over the world. As of yesterday, the database had just shy of 2,600 cases, and in those cases, more than 13,000 documents are available on the database. I encourage you all to go and check out some of those cases. You'll find that there are cases there that have been filed in more than 50 countries, brought under numerous laws and other legal theories. Some cases are seeking to force or enforce climate action, namely through the creation of new or stronger laws and regulations. Some cases center on constitutional issues and the extent of fundamental and human rights protections. Others seek money damages for current and future climate impacts like wildfires and sea level rise. All of these cases have generated considerable interest and commentary, not only among the legal community, but more broadly as well. And as evidence of this, last August's decision by a trial court judge in Montana in the Our Children's Trust-backed case Held versus Montana made international news as the first youth-led climate case to go to trial and obtain a judgment that declared the state constitution of Montana protected a right to a stable climate, and the Montana law at issue violated that right. Without a doubt, it's a fast-moving field, and many groups are laser-focused on its direction and outcome. Fortunately, I have four distinguished panelists with me today to explain this growing global phenomenon that is strategic climate litigation. We'll hear both international and US perspectives and dimensions, and get the perspectives from the people who've actually worked specifically and closely on some of these cases. So I'll keep my introductions very brief, but I encourage you to check out, obviously, their full bios in the program. In order of the presentations, Amelia Burnett. She wears several hats. Amelia is a visiting scholar at the George Washington University Law School, obviously here, a PhD researcher with the University of Strathclyde in Glasgow, Scotland, and she currently serves as director for the Climate Change Legal Initiative. She practiced complex litigation earlier in her career and was a senior attorney with the Southern Environmental Law Center, where she advocated for protection of forests and for proper accounting of climate impacts and resiliency. Our next speaker, who will help illuminate some of the aspects of what is happening in strategic climate litigation at the international level, is Samantha Dirksen. Samantha is an associate at Hausfeld, a law firm based here in Washington, D.C. She's also a GW Law grad. And Samantha and Hausfeld have deep experience in climate change litigation, having represented many youth climate activists, including Greta Thunberg. And recently, Sam led Hausfeld's representation of youth climate activist organization FACE, Intergenerational Justice, who we heard a moderator from earlier today, in its amicus submission to the Inter-American Court of Human Rights. Following Samantha will be Paul Rink at the end. Paul will share insights from their time at Our Children's Trust and from their research, which looks to situate strategic climate litigation within the broader climate movement. Paul's a visiting assistant professor at Elizabeth Hobbs School of Law at Pace University. And before moving to Pace to teach, Paul was a global staff attorney at Our Children's Trust, who we've heard from several times so far today. And rounding out the panel is Leonard Crippa, an international law scholar with substantial legal experience and currently a senior attorney at the Indian Law Resource Center. For more than 20 years, Mr. Crippa's practiced law in the field of human rights and has represented several human rights victims and indigenous communities before the bodies of the Inter-American human rights system. With that, take it away, Amelia.
So I'm going to go. situated. Okay, this mic's a little far away. Can you guys hear me? Yes. I won't shout. Okay. Let's see if I can work a clicker and a laptop at the same time. I'll try not to be too technology impaired here. Aha. Okay, so I want to start with just our topic, strategic litigation. So what do we mean by calling it strategic, right? I mean, it can sound a bit like a buzzword. It's often used to describe right now cases being brought to hold governments accountable in relation to climate change, for example. But in more simple terms, if I think back to my practice as an environmental lawyer, lots of litigation can be considered strategic in that what you're trying to do is use a particular strategy to achieve a particular outcome. Another scholar in the field has noted that the craft work of litigating lawyers is always about calculated action. So if that's true, what do we mean by strategic here? Well, I would argue that here we're looking not just at judgments obtained within a lawsuit, but we're taking a larger horizon. And today I'll discuss ways that human rights in particular are being invoked in climate litigation with a focus on the strategic potential towards shaping and supporting larger shifts in the law. So this relates to my own PhD work over the last few years, which was looking to see how human rights are being used and to what effect. So I hope that by using this lens, we're able to see the legal innovation that's happening in the space of adjudication. To set the stage here, human rights appears more prominently in climate litigation following a few early landmark cases. In the last decade, and the adoption of the Paris Agreement in 2015, which made reference to the human rights obligations in the context of its preamble. Now, many of these cases have been high profile. You've probably heard about some of them already today. You may know some of them. But in fact, at this point, there are decisions involving human rights and climate change now in every region of the world, and some of them are lesser known. These cases involve a range of litigants, including NGOs, youth litigants, climate-impacted communities, indigenous groups, and other disadvantaged members of society, and they involve a whole range of courts. They involve domestic courts, you have regional courts, and international treaty bodies adjudicating claims at the nexus of human rights and climate change. This means that courts all over the world are on the forefront of deciding claims that are both at local scales and connected to a larger global problem. Now, just to name a couple of trends, although the United States has most climate litigation generally happening, human rights-based cases are actually most concentrated right now in terms of decided cases in European countries, and then Latin American, and then North American countries. So as opposed to climate litigation generally, there's more of an even distribution in the context of human rights climate cases. Now, what about the rights? What do you think is the most often invoked right in the context of climate litigation? You can guess in your head, you don't all have to shout. Well, if you guessed the right to life, you were right. The right to life is the most often invoked right in this context, by a long shot actually, followed by the right to health or well-being, and then the right to a healthy environment. But there are other rights playing a role in these cases as well. The right to culture, the right to liberty, the respect for private and family life, the rights of the child, territorial rights. So if there are so many rights, what are the legal origins of these rights? Well, most cases, rights-based climate cases, are in national courts. And about 3/4 of the cases that I looked at were invoking rights in national constitutions. But beyond national constitutions, of course, there are rights from regional human rights conventions and international human rights treaties. Most often, rights violations are invoked in combination, so not just one right. And naturally, which right is invoked plays a role in what kind of issues a court has to adjudicate. And I'll make this point just briefly because it will become evident later why it's relevant. But for example, if a court is evaluating a violation of the right to culture, That's going to require one kind of analysis, or a violation of a right to life, that's going to require a different set of questions to be answered. But in particular, the temporal scale of the harm, the future forecasting that the court has to do to decide if this rights violation is imminent, is it immediate, does it need to meet that test? These are the kinds of questions coming up in these cases. But stepping back for a second, if we have this broad tapestry of rights being invoked in different geographies, different legal cultures, different factual scenarios, what can we see across the cases? So today I will focus on three main themes: bridging accountability gaps, seeking intergenerational justice, and participating in shaping our energy future. So first, cases invoking human rights are being used as a tool to bridge gaps within and between climate governance regimes. We can see multiple cases that are pushing climate ambition, for example. So these are cases where litigants challenge national or subnational government policy as lagging behind the international and regional climate regimes. So these cases include arguments that unambitious national climate action is insufficient to protect human rights. A specific example would be in Belgium, the NGO Klimaatzaak, and I may have not said that correctly, and several thousand co-plaintiffs challenged, several thousand, that's how many plaintiffs you have, okay? Challenged Belgium's climate policies, including on human rights grounds, as too lax to achieve net zero by 2050, a pathway itself that's designed to meet the Paris Agreement's targets. In terms of climate harms, the Belgian court described the risk of flooding, water shortages, impacts on human health as sufficiently real and imminent to impair protected rights. That court issued injunctive relief, requiring reductions at the appellate level anyway, requiring reductions to domestic emissions by 55% in 2030, in line with the EU's greenhouse gas reduction targets. This notably went beyond the only declaratory relief that had been issued by the lower court. The lower court was worried about intruding into the political spheres, but on review, the appellate court went ahead and issued injunctive relief. Now, the Belgian court referenced reasoning from another landmark case that you may be familiar with, the Urhinda case in the Netherlands, where the Dutch Supreme Court affirmed the relevance of rights under the European Convention on Human Rights in requiring a more ambitious pace of reductions towards the Paris Agreement's temperature goals. Now, a newer trend in this area sees litigants looking to human rights in the context of cases scrutinizing nationally determined contributions. These cases show a trend, all of these cases, though, show a trend towards human rights stepping in to accountability gaps that are currently in the law. They also show how court interventions can catalyze climate action. Second, human rights cases are also being used to push intergenerational justice. Now, I think this is something that's been touched on today. But these cases ask, who bears the future impacts of policy choices now? So decisions made today to mitigate the impacts of climate change and to ensure planning for climate resiliency will have a major impact on the enjoyment of multiple rights in the future, including life, including health, including the right to a healthy environment. And these themes, of course, are especially prevalent in youth-led litigation. In the space of these cases, courts are being asked to connect climate predictions of future impacts to present policy decisions, aided by scientific models, but also aided by local observations of changing conditions. This includes the Neubauer case, where the German Constitutional Court used the concept of intergenerational equity, focusing on the present generation consuming too much of the carbon budget now, in effect offloading the burden of reducing that into the future, onto future generations. The court recognized that inaction now on climate change means drastic measures will have to be taken later, and that is an interference-like effect into the rights of subsequent generations. And then, of course, there's a landmark decision from Colombia that also uses this idea of intergenerational equity, noting the children who brought the action will be directly affected in the future unless Colombia reduces Amazon deforestation now. So adjudication in this way is really helping to pull into focus how intergenerational equity should be shaping climate policy decisions. It's not just about the outcome in a particular lawsuit. It's about showing us how climate policy needs to respond. And then my third, and these are not exhaustive. We could keep coming up with points, but I'll stop after this one. The cases are providing a means to ensure that those impacted by current decisions have a role in shaping our energy future and in pursuing climate justice. So these cases may arise under many different project authorizations and practices in different parts of the world, but the central theme is ensuring governments, in considering everything from coal plants to mining and even to renewables, are asking the necessary questions to ensure protection of human rights. So we can see this in the South African case challenging the Thabametsi coal plant, which was going to use large amounts of water in an area already suffering from water scarcity. The South African Supreme Court relied on the right to a healthy environment in their constitution to require a climate change impact assessment that included climate as a stressor on water supplies and had to analyze how South Africa's projects like this will fit with South Africa's longer horizon under its international commitments, its bigger commitments to reduce reliance on greenhouse gas-emitting industries. Eventually, and with more advocacy, that coal plant was withdrawn. Now, in Norway, plaintiffs challenging new license for deep-sea oil and gas extraction in the Barents Sea also asserted a violation of multiple human rights under the Norway Constitution and under the European Convention on Human Rights. Now, although the Norwegian court acknowledged, the Supreme Court, that climate change may lead to loss of human lives, for instance, through floods or landslides in Norway, it found those threats only discernible in the more distant future, and it upheld the licenses. The plaintiffs have now pursued their case before the European Court of Human Rights, although it's temporarily adjourned, pending 3 other climate and human rights cases that will be decided imminently by the Grand Chamber. So similar questions are coming up in cases about how to manage carbon sinks, addressing deforestation, how to navigate a demand for mineral supplies in the energy and technology sectors in a way that comports with climate justice. So at this moment, we can see adjudication itself being an area of legal innovation where global problems manifest on local dockets, sometimes with a disruptive effect to the ordinary application of legal doctrines, like standing. In terms of argumentation, human rights are serving as a way to amplify the human dimensions of climate change harms. Its place-based focus can help reshape the narratives in cases that can be otherwise heavily technical and scientific. So science tells us the seas are rising. Human rights tell us that graves are flooding. Science tells us that there's inundation, but human rights tell us that the gardens are withering from the inundation. Science tells us marine systems are changing. Human rights tell us of the loss of livelihood to the fishermen. In terms of broader strategic value, human rights are effectively being used alongside other legal strategies to provide a mechanism to push for greater ambition, to pursue intergenerational justice, and to assure participation and access to justice in shaping our energy future. And although each of these decisions might seem incremental, these kinds of decisions can represent turning points and have a shaping force in how we respond to large environmental problems like climate change. And that's the end of my presentation.
Perfect. Thank you so much, Amelia. I think now we're at least situated in knowing what is strategic climate litigation. And so now we'll turn to Sam, who will provide us some perspective on what's happening at the international level.
Yes, thank you.
Well, before I begin, I just want to thank Jared for his kind introduction, Dean Randy, who I don't see at the moment, for inviting me to come here, and all of you guys. I want to thank you all for putting in the time and the energy and the passion into these issues that it deserves, and it's really, truly, I feel honored to be here amongst you guys today. So, as Jared said, I work for Hausfeld. Hausfeld is a global claimants firm. We are passionate about many things, and amongst which environmental and public health justice, and that, of course, includes climate justice. And today, I want to talk a bit about strategic climate litigation at the international law level. So that includes both at the international level as well as at the regional level, for example, in regional human rights courts. But before I do so, I want to sort of generally touch upon strategic litigation. And Amelia, I agree with everything that you said. I think strategic litigation is litigation where it isn't just about the case you have in front of you at that moment, about the litigants in that case. It is about trying to open a door, trying to establish a principle, trying to establish a presence that then will help others as well. And in bringing a strategic litigation, I think it's important to think about what is the right case, what are the right facts, who is the right plaintiff, who are the right defendants, what's the right forum. And so I wanted to stand still and think about that for a moment. So I think when it comes to climate change, as we know, everyone is affected. So in a way, everyone is a potential claimant. Hausfeld has, in the recent years, represented a lot of youth activists. And as you have seen this morning in the panel, the youth activists really bring the passion, they really bring the energy, and I think they have the best insights of us all. So thank you for that. And so it's been really an honor to represent them. And also, they're the ones that are affected the most. The young people, the people who are yet to be born into this world, they are the ones who are going to live with climate change for the longest. And they're also the ones who have contributed to it the least, if at all. And so I think that they have really been an amazing claimant in climate change cases and have been amazing to work with. Then in terms of the forum, because I think all of the laws in the world basically need to catch up with climate change. In a way, we need cases in all forums. We need cases at the local level, the domestic level, the constitutional level, at the international level. So in that sense, that one is easy. We need them everywhere. And that kind of brings me to sort of expectations. I think, Amelia, you said it really well, like all the cases that you discussed are incremental in a way. And not any single case is going to get us where we need to be. And it's okay sometimes to, not win your case entirely the way you hoped. Often cases establish one principle that's part of the bigger puzzle, and then another case comes along, and that takes that principle and brings it home even further. And then this is my snowball theory, by the way. I don't know if you can see it. But, at some point the snowball becomes big enough and it becomes impossible to ignore. And all the cases that, we all bring contribute to this, and they're all important. So then, lately at Hausfeld, we've been focusing on, or one of the things we've been focusing on are cases at the international law level. So I want to sort of take a step back and talk about the legal framework at the international level. So there are currently several proceedings that are aiming to define what the obligations are of states in terms of climate change. And people might think, okay, but aren't those obligations defined under the UNFCCC, which is the United Nations Framework Convention on Climate Change? And that is indeed the framework under which states have gotten together to negotiate about their obligations, and often they aren't obligations. The problem is that they are voluntary commitments. But as states like to point to this and say, well, those are our obligations. We don't have any other obligations. But actually, there are other bodies of law out there, including at the international level, that also affect climate change, or climate change affects these laws. So even if a state, didn't make a voluntary contribution under the Paris Agreement, that doesn't mean that that state doesn't have obligations to adapt to and mitigate climate change. There are other laws out there that mean that they have these obligations, and there are just proceedings at the international level currently that are trying to establish precedent on that point. So obviously one of the most important laws in that sense is international human rights law, as Amelia touched upon. And so there are currently proceedings in this field. But even though these international human rights law might create obligations above and beyond the UNFCCC, what's important is that these sort of fields of law, they don't operate in a vacuum. So international human rights law is informed still by the UNFCCC. It's informed by international environmental law and international climate change law. And I want to touch upon some of the principles that are sort of imported from the environmental international law into human rights law. The first one is the precautionary principle. This is basically a principle to err on the side of safety. So in cases where maybe the science hasn't caught up to reality yet, or maybe causation isn't that clear yet, as we know is a problem in climate change. The precautionary principle requires states to err on the side of safety and take measures, even though there might be some level of uncertainty about the effects of their measures. And this is a really important principle that can be used to hold states accountable. Then there is the principle, the common but differentiated responsibilities principle, sometimes also referred to as the common but differentiated responsibilities and respective capabilities principle. And this is a principle that was developed under international climate change law, and it encapsulates different ideas. It encapsulates, on the one hand, the idea that the obligations of states is a common one, that all states have an obligation. But on the other hand, it encapsulates the idea that states have different culpabilities when it comes to climate change, and they have different capabilities in terms of addressing climate change. So this principle sort of says that everyone should do something, but who does what it's not that everyone should do the same. And so that principle is also sort of imported from the environmental sphere into the human rights sphere. And then the last one we've touched upon it several times today is intergenerational justice. And this is also a principle firmly rooted in international environmental law. It essentially is at the ground of sustainable development. And the idea about sustainable development is that we develop in a way that is sustainable for future generations. So that is, and the Rio Declaration and other agreements have incorporated this intergenerational justice idea, and now that's also making its way into human rights law. So in that sense, they do not operate in a vacuum. And we can borrow from international climate change law, even though it's very clear that that isn't the only obligations that states have. And Amelia has also touched upon the different rights that are often violated with climate change. So the right to life, the right to health, the right to food, the right to water. Sometimes in some treaties, there is the right to a healthy environment. And essentially, you could argue that all human rights are impacted. I mean, climate change impacts every aspect of our life. And so often these cases have been focusing on certain rights, but I think there's an argument to be made that, in fact, every aspect is impacted. So then I want to turn to sort of talking about specific cases that have been brought at the international level. So first, I'm going to go back into time a little bit to 2019, when 16 children brought an action before the Committee on the Rights of the Child. And they alleged that 5 nation states, Argentina, Brazil, France, Germany, and Turkey, violated their rights under the Convention on the Rights of the Child by not sufficiently taking actions to stop climate change. The reason I go this far back in time is that I think this case actually sort of demonstrates my snowball theory. So the outcome of this case can be seen in different lights. We can look at it pessimistically and say, unfortunately, this case was not successful. What happened was that the case was thrown out on a procedural ground. It was thrown out on admissibility, on a theory under international law that's the exhaustion of domestic remedies. So essentially what that means is that they faulted the children for not first going to the domestic level courts in the respective nation states, and then only after that failed going to the international courts. The children argued that that would have been futile, they wouldn't have gotten what they needed, but unfortunately the committee rejected that argument. However, I think that the better way to look at this is in a positive light and look at the things that the case did establish and the building block that it formed for future cases. So actually, on the substance, the committee agreed with many extremely important points that the children brought to it. So first of all, it agreed that climate change did impact the rights of the children. That's huge. Then it found that states did have extraterritorial obligations under human rights law. And it also found that the collective nature of climate change doesn't mean that each individual state doesn't have a responsibility. So this goes back to the common but differentiated responsibilities principle. So all those 3 points were really important to have established, even if the children didn't get the outcome that we obviously hoped for. But the committee, made these important findings and then also used this case to then publish a general comment, which is sort of an interpretation of what the rights of states are. And in those general comments, it repeated a lot of these principles that I just mentioned, a lot of these findings that I just mentioned. And that general comment is now used in other litigations. So for example, just last week, there was an important decision by the Inter-American Court of Human Rights holding Peru accountable for not protecting its citizens in La Oraya for the devastating impacts of a smelter factory and all the toxic pollution that it caused and all the health impacts that it caused. And one of the things that it cited is the general comments. So I think that sort of demonstrates that even sometimes you lose a battle, but you may still win the war in the end. So then the other case that I wanted to touch upon is two are advisory proceedings. So advisory proceedings are a bit different in that it isn't a contentious case. There isn't a plaintiff suing a defendant. Rather, it's an entity, whether it's a state or something else, that goes to the court and asks the court to sort of authoritatively interpret what the obligations of states are in this case. So there's one pending before the Inter-American Court of Human Rights, and then there's one pending before the International Court of Justice. As Jared mentions, we represented FACE in their submission to the Inter-American Court of Human Rights. And the Inter-American Court of Human Rights has been very open to receiving submissions from civil society. So there have been states, there have been NGOs, international organizations, academics, indigenous groups who have all submitted amicus curiae brief to the courts. And currently we are at the stage where we'll have 2 to 3 days hearings. And we're hearing from all these aspects of civil society, and then the court will render its opinion after that. At the International Court of Justice, the process has been a bit different. Obviously, at the Inter-American Court of Human Rights, the question to the court has been about what are the obligations under human rights law in the Inter-American region. Whereas in the International Court of Justice, the question has been much broader, and the ICJ has been asked to look at various international laws. So in addition to human rights law, they've been asked to look at international climate change law and also at the law of the sea, as well as general principles and customary international law and whatnot. So that is one way in which it's different. It's actually much broader. The other way in which it's different is the ICJ, as you may know, is a state-to-state court. And this has also resulted in civil society playing less of a role in that proceeding. So it's only states and international organizations that have been able to be allowed to make submissions towards the courts, which we and our clients think is a shame, as we do think it is really important that everyone in civil society has a voice in these forums. And the status of that is that I believe they've just had a deadline for their first submission, and then later there will be the second submission. The hope is that the Inter-American Court of Human Rights renders its decision first, which then hopefully will influence the ICJ's decision. Then I should note that these are by far not the only proceedings going on at the international law level. I have a limited amount of time, so I wanted to touch upon some, but people have mentioned the cases before the European Court of Justice, the European Court of Human Rights. There is also an advisory proceeding before the International Tribunal on the Law of the Sea. So there's lots happening at the international level, all aimed at defining what states' obligations are towards its citizens and citizens of other states with respect to climate change. And then lastly, I just want to touch quickly upon what can we expect from this? What are sort of the best case or worst case scenarios? So, of course, what we hope is obviously for good decisions that define robust obligations for states, both with respect to adaptation, mitigation, damages. And then we, of course, hope that states will act accordingly. But that is something that I think we need to stay on top of it. It isn't just about getting that decision and the decision saying what we wanted to say. We need to make sure that the decision is also enforced afterwards. So one of the things that we've done with FACE is suggest certain enforcement mechanisms to the Inter-American Court of Human Rights in terms of how it should monitor states after its decision and make sure that they actually implement the decision. So I think that is one important thing to think about even after you've won. And then I want to end on a positive note. So I also want to briefly touch about a positive case in the Netherlands where international law and decisions at the international level were actually used in domestic litigation. So this is another thing that maybe we can hope for from these international proceedings. What happened in this Dutch case, which is the case Milieudefensie against Shell, is that Shell was sued for its contributions to climate change. Milieudefensie won, although I should say it's currently on appeal. So let's see what happens. But the courts granted broad injunctive relief, and Shell was, the court didn't grant any damages, so retroactively, unfortunately, there was nothing, but sort of like in the future, there was an injunctive relief where Shell was made to cut its emissions. So that was a really great decision. But the interesting thing about it, for my purposes, is that the case was brought under an unwritten standard of care, so something that here, like a normal sort of negligence tort law. And as it's unwritten, the court looked at many different things to interpret what that standard of care was. And one of the things it looked at was international law. And this is actually really groundbreaking because we normally know international law as something that is about states, but the court actually looked at international law in a case against a company. And they looked at human rights law, and they also looked at the UN guiding principles about how human rights imposes obligations on corporations. Those guiding principles are what is known in international law as soft law, so they're not hard obligations. And so it was really very sort of novel for the court to use these to interpret the obligations of the corporation under the domestic law. But it was a great step, and I hope that it's upheld on appeal. But that is another thing that we can hope for from these international proceedings, that maybe they can be used in domestic litigation afterwards. And on that note, I will conclude.
Thank you so much, Sam. In many ways, it feels like you all are sort of at the leading edge of what's happening at the international level, and it feels like we're sort of at a precipice moment, sort of maybe in the next year or two, with several decisions coming out from international bodies, or at least advisory opinions on states' obligations. So stay tuned, everybody. Let's kick things over now to Paul, who will give us I think some of his own experience with Our Children's Trust, but also situate strategic climate litigation within the broader climate movement. Over to you, Paul.
Thank you. Thank you so much. Yes, and I also want to express my thanks to everyone in charge of organizing this panel and this event. Very grateful to be here and to be with all of you today. And so, as was mentioned, I worked at Our Children's Trust from 2020 until August 2023, and that's going to be the bulk of my talk today. And having just thanked this law school and everyone involved in organizing, I have to take a little leap of faith and actually conflict with something that was said by the dean earlier today when she was giving her introductory remarks and mentioned that Juliana versus the United States was ultimately not a success. So actually, Juliana is still alive, and that's what I'd like to start talking about. And I would also like to think about what success means in these cases. So I'm actually working on research right now that's really thinking about that question, and I'll touch on that toward the end. But for now, I'm going to actually just focus in on what's going on at Our Children's Trust and what's sort of the new litigation that's coming out and what's happening with some of the cases that have already been filed. So, there we go. So Juliana versus the United States was filed in 2015, It has a lengthy procedural history, which I'm not going to go into for the sake of time today. And as you can see from this slide, I'm going to start 5 years later in 2020, when the Ninth Circuit actually dismissed the case on procedural ground known as standing. In fact, it was a subpart of the standing requirement. There are 3 requirements under standing, which are having a causation, having harm, and having the ability to redress it through the courts. And both the district court and the Ninth Circuit came down resoundingly that the plaintiffs had shown that they had both harm from climate impacts and that they had shown causation by the government. What the Ninth Circuit found is that the courts are the improper venue for addressing those harms. They said this is something that's a political question that's better addressed to the political branches of government. And even suggested that many of the plaintiffs, some of whom are not old enough to vote yet, go to the ballot box to try to fix this problem, ironically and frustratingly. And so after it was dismissed in 2020, there were 3 years of procedural events that occurred. And actually what ended up happening is the young plaintiffs filed a second amended complaint that took into account this consideration of redressability by the courts. Because what the courts had said is some of the types of redressability that are remedies they were seeking were unable to be addressed by the court because it was something that the political branches needed to be doing. But what they said it was around the injunctive relief they were requesting, essentially changing the energy system. What the Ninth Circuit decision left unaddressed was whether the declaratory requests for relief could be addressed by the courts. And so the young plaintiffs reframed their complaint and said, okay, well, if you can't address our injunctive requests, perhaps you can focus on our declaratory relief requests, because that is actually the sole province of the judicial system, is to declare what the constitutional law means. And that particular claim and complaint was able to move forward again at the district court level, bringing Juliana back to life. Now in 2024, the Biden administration has sought a writ of mandamus to basically procedurally upend the case in something that has become very familiar across 3 administrations, starting with Obama, moving into Trump, and moving into the Biden administration. And this is something that I know very well myself, because one of my jobs when I was at our Children's Trust was to go back into the procedural history of Juliana versus the United States and find out exactly how many writs of mandamus have been filed by the US federal government. And for those of you who are lawyers, you're probably well aware writs of mandamus are very rare procedural attempts to kick a case out of court. And there were 6. So this one that was filed in 2024 is the 7th writ of mandamus that was filed in Juliana versus the United States since it was conceived. So the question becomes, why is the federal government trying so hard, using so many obscure tactics to keep the case out of court? And that's something we're going to explore in the future part of this presentation. But for now, I wanted to focus in on the fact that when this case was filed in 2015, the plaintiffs were of varying ages between, I believe, 8 and 19. And Kelsey Juliana, the main plaintiff in the case, is the one wearing the yellow scarf in this photo. She was 19 when the case was filed, and she just turned 28 a month ago. Levi, the youngest at the time of filing in the blue jacket and the big hair, was 8 and is now 16. Nathan Baring, the tallest one in the back with the winter cap on and the red jacket, a remarkable young man. He's from Fairbanks. He was 15 years old when the case was filed, and he's now finished college and has returned to Alaska to be the program director for a reindeer herding organization. Very cool. And then I wanted to end, I could go through all of the plaintiffs, they're all amazing. But Tia Hatton, with the flaming red hair on the far left hand of the screen for you, she was 18 when the case was filed and now lives with her partner in Flagstaff and her 2 dogs. And the reason I wanted to end with Tia for this slide is because there was a profile on her after the Montana decision came down, in which she said, I was really energized by the decision in Montana versus Held, in a way that, after being in this case for 8 years, the energy kind of ebbs and flows, and I'm sure it was a period of downtime at this period. And she said, Montana, the case in Montana, shows that when it's all laid out, we have a solid case. And I really want to hone in on that, and I want to explore that with this presentation, and what is the US government and all of the state governments that these cases are being filed in, why are they working so hard to keep these cases out of court? It's because when the evidence is presented, it's a very strong case. The hardest part, especially in the United States, is to get the cases to trial, right? There's a lot of procedural hurdles, but when you actually look at the evidence, these cases can and do win. And so Held versus Montana opens up hope not just for Tia, but for many youth plaintiffs in the United States, and as we'll talk about a little bit later in the presentation, globally as well. But so that provides a transition to the Held versus Montana case, which I'm sure many of you have heard about and has been discussed today, even by Jared. And this case was filed in Montana, and it was filed asking for a number of different types of relief, very similar to the Juliana versus the United States case. And so you can see here one of the plaintiffs, Grace Gibson Snyder, and many of her other co-plaintiffs, basically ultimately won their case on the question of did they have a constitutional right under the Montana state constitution to a stable climate system? And if so, did the government's behavior, specifically with an exemption under the Montana Environmental Protection Act, which basically disallowed the consideration of climate change when deciding if they should allow fossil fuel production to move forward, whether that violated that constitutional right. And Judge Seeley in the district court determined that both that right exists and that it was violated by this MEPA exemption. So what I wanted to highlight for this particular point is that the original complaint for this case actually asked for expansive relief, both injunctive and declaratory, in the same way that Juliana did. And very similarly to Juliana, the declaratory relief actually got removed at the motion to dismiss phase, and the requests for the injunctive relief got removed at the motion to dismiss phase, and the declaratory relief got heavily narrowed at the summary judgment phase. And basically what ended up happening is the case won on this very narrow ground of exemption of the Montana Environmental Protection Act exemption. But a lot of its bigger claims of asking for the Montana state energy system to be changed, asking for the Montana state government to be held accountable for its aggregate acts that fed into the fossil fuel infrastructure system, those weren't able to move forward in court. And so I think this kind of goes to show that shifting focus and honing in on a particular aspect of the climate crisis in these litigious approaches, specifically around declaratory judgment, is something that can really be resonant in courts, and it is reminiscent for Juliana and other cases. But what does that mean in terms of how this case, Held versus Montana, can be applied to other cases? And I think one of the main things to focus in on are, well, there's three that I want to highlight for this particular presentation, and I'm going to go into them, each one of them in more depth in the next 3 slides. The first is that focusing on in cases in states where there's a constitutional provision in its constitution allowing for the right to a healthy environment can be really successful in court and can give judges something to latch onto in order to come up with these decisions. The second is that expert testimony at trial matters a lot and is really difficult for the government defendants to counter in a way that allows them to keep these cases from succeeding. And the third thing is, as mentioned before, narrowing complaints to particular provisions or agencies can actually really help these cases succeed in a way that is being learned through cases like Juliana versus the United States and Held versus Montana. So, like I said, with the next 3 slides, I'd like to focus in on how OCT, our Children's Trust, is really incorporating these strategies into their cases moving forward. So, the first thing to notice is, these are the 3, as I just described. And so the first thing to notice is in their case, Navahine versus Hawaii Department of Transportation. This is a case that was brought in a state that has a constitutional right to a healthy environment. And this case, the person speaking at the podium is Kala Winter, who is a climate activist and is one of the plaintiffs in the case. She and her 13 co-plaintiffs are suing the Department of Transportation for developing and supporting a fossil fuel-based infrastructure that leads to high amounts of greenhouse gases. Not a fossil fuel infrastructure, a transportation system. So basically the way in which they've laid out roads in Hawaii and the way in which they support fossil fuel guzzling engines in cars, that is something that's basically violating the rights of these young plaintiffs. And they're relying on this particular provision in the constitutional law of Hawaii, Section 1 of Article 11, which talks about future generations very explicitly and says that the natural resources of Hawaii and its natural beauty need to be safeguarded specifically for those future generations. So this is something that is uncontestable and explicit in the Constitution, And that's one of the reasons why this case has a lot of promise and is basically taking the strategy developed in Held versus Montana and moving it forward into other states. Now, not every US state has this kind of a constitutional provision, but there are others, including New York, and I think altogether there's 5. And so that's something to consider when bringing these cases in the United States. So the second thing that I mentioned before is courtroom evidence and expert testimony. And I think this is one of the really undersung things that can be learned from Held versus Montana in other cases, particularly in the United States, but also in other jurisdictions. So in Judge Seeley's decision, where she basically determined that there was this constitutional right under the Montana Constitution, and in which she declared the MEPA exemption unconstitutional, she cited climate science almost 1,000 times and relied heavily on the expert testimony that was provided by the plaintiffs in the case. In contrast, Montana actually billed only 3 expert witnesses, and that didn't work for the state government. So they did have some state government officials, but there were only 3 expert witnesses who weren't actually employed by the state itself. One of them was named Dr. Deborah Shepard. She is a neuropsychologist billed as a mental health expert. She never took the stand, but did admit in her deposition that she had no expertise in how climate change affects the mental health of young people. The second is climatologist Dr. Judith Curry. She was touted as the government's star witness, and she expressed relief in her blog when she was let off the hook, using her own words, from having to testify in court by the State Department attorneys. This relief came after a full week of expert testimony that was provided by the plaintiffs, and she didn't say that's why she felt relief. She just said that she felt relief, so I'll leave that with you. But what was also determined was that the third person who was expert witness, Dr. Terry Anderson, was the only actual expert witness to take the stand on behalf of the State Department. And in cross-examination, he admitted to submitting incorrect calculations in his expert report and misrepresented the state's emissions in his expert report as well. He later corrected those things, but in the original report, it was incorrect. So ultimately, Judge Seeley, in her decision, determined that Dr. Anderson's testimony was not well supported, contained errors, and so she didn't give it any weight in her decision at all. In contrast, well, actually, really quick, what I'll sum up with saying is Dr. Deborah Shepard, Dr. Judith Curry, and Dr. Terry Anderson billed the state of Montana $95,000 for the work they put into crafting their testimony. In contrast, the 8 expert witnesses that were provided by the plaintiffs were all doing their work pro bono and were get paid only for their out-of-pocket expenses coming into Montana. So when we talk about shifting narratives in the courtroom, this is actually an undersung aspect. When you actually put this stuff in front of a courtroom, there are people who are unwilling or concerned to come into court and defend state behavior, but the people who are willing to stand up on behalf of plaintiffs do so without getting paid and with a strong sense of moral conviction. So on that note, in relation to Juliana versus the United States, which has not yet gone to trial, but hopefully one day will, there are several expert witnesses on deck who have already provided expert reports, but are ready to provide expert testimony as well. One of those is Dr. Jim Hansen, a prominent climate scientist who testified in front of Congress in 1988 on the dangers of global warming. He was the first person to really bring this to the public's attention in a Senate testimony. And not only is he an expert witness in Juliana versus the United States, but his granddaughter, Sophie, is one of the plaintiffs. Another one of the many examples I could choose from is Dr. Joseph Stiglitz, who is the former chief economist at the World Bank, won the Nobel Prize in Economics in 2001. He has written an expert report for Juliana versus the United States and frequently writes op-eds in media in support of the case. So that's the kind of thing that the federal government will be up against when Juliana goes to the trial. So the newest case that's been filed by Our Children's Trust is called Genesis B versus US EPA. This case was filed in December 2023. And it's specifically against the Environmental Protection Agency in furtherance to the third point that I brought up before, which is when you narrow these cases to particular provisions or particular agencies, that can carry a lot more power and a lot more leeway for the court to really grasp onto the arguments. So in this case, well, and actually, this also goes to the point that it's very difficult for the government to refute the kind of evidence that's presented in court. Because in the complaint for this case, the plaintiffs have actually outlined through government documentation, explicitly from the government, all the things that support the allegations they're claiming are happening in terms of the US government's inability to respond to what is needed to be done to protect the rights of children. So in relation to the Environmental Protection Agency, the lack of regulatory action on greenhouse gas emissions has taken place over the course of 5 decades, despite the fact that there have been many circumstances in which the US EPA has either been told they need to act, has recognized that they need to act, or has been mandated to act by a courtroom. So in 1974, this is sort of when the EPA came to know of the threat of global warming for the first time. They explicitly commissioned a report on changes in global energy balance in that year, trying to predict, to see if the modern era increases in atmospheric CO2 were going to take place. And that report did actually determine almost very accurately how much, in terms of parts per million of carbon dioxide, is going to come into the atmosphere over the course of several decades. Then in 1983, the EPA expressed that a wait-and-see attitude may mean waiting until it's too late when it comes to carbon dioxide emission pollution. This is in 1983. In 1999, they received a petition for rulemaking to issue an endangerment finding on greenhouse gases, and they sat on that for 10 years. Then in 2009, they actually issued that endangerment finding, specifically because they were forced to by the decision Massachusetts versus EPA in 2007. They actually rejected a petition to establish a national ambient air quality standard for greenhouse gases in 2021. And this is the outlined history of documented failure that the plaintiffs are presenting in their case to try to hold the EPA accountable, not only for their lack of action here, but for their essential endangerment of human life into the future, and particularly those of young people and future generations. So with all of that happening in the United States, I also want to draw quick attention to what Our Children's Trust is doing in the global arena and how cases that Our Children's Trust has brought, along with many other law firms, including Hausfeld and others around the world, are really helping to create this snowball effect that Sam mentioned earlier and create this galvanizing effect around the world. And so youth-led climate litigation has really inspired youth activists around the world and has inspired further litigation in places from Australia to Canada and in international tribunals from the European Court of Human Rights to the International Court of Justice that has been mentioned today many times. But in addition to facilitating a worldwide movement for litigation, it's actually really helped in terms of allowing these cases to come in front of jurisdictions and tribunals that are much less likely to have the kinds of procedural hurdles that we've seen in the United States. So although some things are actually taking place in terms of procedural complications in other countries, there are actually a lot of jurisdictions that are more favorable to these rights-based cases and are less likely to have them thrown out on a procedural technicality and are willing to hear them in court. And that's something that is a huge impact of these cases, because if the US is a really difficult jurisdiction to bring the cases in, if they inspire cases in other places where they can be filed and lead to some successes, that can further create this galvanizing effect. And because climate change is a global problem, litigious forum shopping for different jurisdictions is something that's totally feasible and totally able to happen. But I'd like to conclude by saying, when we think about the success of climate litigation, ultimately, they don't succeed by winning in court. In fact, winning in court in many ways could be really beneficial, but will not have the more important and primary impact. The more important primary impact is what's happening now as these cases are being talked about, as they're galvanizing further action, reframing narratives, and shifting perspectives. In particular, they're giving voice to young people. And that's something that is really, really resonant, especially as we're going through a period of time in which youth climate anxiety and climate anxiety more generally is a huge issue and is only growing further. And I think it was something that was mentioned yesterday during one of the talks, or maybe it was today, but creating action is the best way to defeat nihilism and despair. And that's something that's really important to pay attention to. And this is true for all of the youth plaintiffs that have been mentioned today, from Kelsey to Levi to Nathan, Tia, Grace, etc., Kala, but so many more, and so many who are in this room today as well. In addition, this kind of litigation can really reframe narratives away from the technocratic and political difficulty of acting on climate change to one that's centered around the moral imperative to do so in a way that has been reflected in pretty much every talk that we've had at this entire conference. That also is not an insignificant impact and can have really broad and big impacts or big effects in terms of giving political actors and judges the impetus they need to really move forward and do the on-the-ground change that needs to happen for the climate movement. They're also raising awareness, and I think this is best exemplified by the courtroom presentation of science. Because unlike in social media or even in the news media, climate pseudoscience can't hold up when it's put to the rigor of a courtroom examination. It just needs the interrogation or the cross-examination by the other lawyers can really poke holes in it in a way that reveals it for the fake news that it really is. And finally, I think the most important aspect of this is the galvanizing action approach, how litigation can really stem into the movements that actually need to happen for things to take place. And we've heard from the first panelists, as well as others across this conference, about what are the things that actually need to be done. And litigation isn't really what needs to be done. Litigation is something that's going to force the hand of powerful actors to do what needs to be done. And I think that's an important thing to take away. Although youth plaintiffs in these cases are inspirational, they can't and aren't doing everything that needs to be done by filing these cases. What they really need is people to step up and see what's happening in these courtrooms to actually facilitate the change necessary to protect their future and preserve the environment and the climate for everyone else as it comes up. So, thank you very much.
Fantastic, Paul. Thank you so much. Here's where I give a little plug for the Environmental Law Institute and our Climate Judiciary Project, because the Held versus Montana case, as you mentioned, sort of in Judge Kathy Seeley's 103-page opinion, was replete with climate science. And our organization trains judges on climate science and the law, and that was an opinion that we went through with a fine-tooth comb, and you're welcome to read our blog or listen to our podcast about the opinion where we talk in depth about the science, me and a climate scientist who's on our staff. We're going to turn now to look at what is happening sort of in these courtrooms. Leo is going to present a case study, his direct experience working on a case in Guatemala with the Maya community. And it looks like you're all ready, Leo, and I'll hand it over to you.
Okay. I feel really moved by all the presentations. I feel like I'm missing something as a human rights attorney, and that is paying more attention to the actual climate change litigation that you guys have been referring to and all the research. I'm a human rights attorney, and so I'm coming from a very different world, and I'm being looked as a foreigner also, because in most of these human rights litigation, I represent native communities, indigenous communities. And so let me share with you some of the work that we do at the Indian Law Resource Center, particularly in this case about the Maya Quechua community versus Guatemala. This is a case that we started to work since 2005, and it ended up with the binding decision from the Inter-American Court of Human Rights in 2023. So that you can imagine that in these 18 years, things happened. And one of those things was this issue of climate change. Another more recent issue is this energy transition discussion happening right now. And for us, it's always been the issue of development finance. All of these development finance projects taking place on indigenous lands, the same as projects such as conservation projects on indigenous lands, and now all the mining for the purpose of the energy transition needs of minerals. I represented this Maya Quechua community it's a community that started working towards securing a land title over the lands for more than 40 years. And we will go through that. But just to let you know, that's the courtroom in Costa Rica, in San Jose. The oral arguments took place during the pandemic, and so we're all wearing masks, and there are a lot of nice cubicles. Basically, we feel like in law school in some way. No public or journalist was allowed in the room, so it was a very quiet place. Okay, let me talk a little bit about the Agua Caliente community. This is a very small community located in the northeast of Guatemala, close to the biggest lake. That's the Izabal Lake. It's a monolingual community. When I say monolingual, I say basically only 5 of the about 360 members of this community speak other language than the Maya Quechua language. They actually speak Spanish. And so in that part of the world, in the Estor municipality, the 90% of the population is Quechua. So it's a very isolated area in Guatemala. And they have a very strong connection to the land. They have in their own Maya cosmovision different terms that reflect that particular spiritual connection, such as Ralchoch. Ralchoch in Maya Quechua means basically that the Maya communities consider themselves sons and daughters of the land. And for that purpose, they have a strong respect to nature and all the actions that they undertake on their lands and the resources that they use within their territories. They have a very strong traditional ceremony called Sultak. Sultak is basically a ceremony that they have at the beginning of any action that will somehow produce a harm to the land or the environment. And so you can imagine that this community facing a mining project on their lands was something that they never imagined. But anyways, I just want you to put you in perspective of a community, isolated, monolingual, with that very native view on how to behave with the land, to make the point that human rights and environmental protection go hand by hand. And it is particularly true when it comes to indigenous peoples, because their physical, cultural survival depends on a healthy environment, basically. Let's move on a little bit. Some facts about this. In 1978, a community created what is called in Spanish Comité Pro Mejoramiento. In English, let's just call it a committee for improvement of the land. It's basically a self-determined institution created by the community for the purpose of taking all actions towards securing a land title over the land. The man that you see in those photos is Rodrigo Todd. He's the president of that committee, and he's the one that led all these legal actions in the last 2 decades. He very recently, in 2017, was awarded the World Environmental Prize because of his achievements as a grassroots indigenous activist, and that's one other reason that this wide environmental protection and human rights go hand by hand when it comes to indigenous communities, particularly in Mexico, Central and South America. Now, what are the issues in this case? Oh, you probably don't see it very well, but in that map, you are supposed to see basically 16 lots. Each of these lots is being occupied traditionally by Maya Quechua communities. The Agua Caliente community occupies lot number 9. And you will see a strip where there is an overlap between about 6 communities and the mining project area, a nickel mining project area called Phoenix. And you may wonder, how is that possible that a lot that has been very much identified since the 1890s is now under the overlap with a mining project area? Well, that's Guatemala, basically. Manipulation of land survey, land registry, titles. That's what happens on a regular basis in this country. The overlap for this community implies about 947 hectares of land, and the overall land that this community possesses is about 1,300 hectares of land. In the 1890s, the Guatemalan state identified these communities particularly the Agua Caliente, in one of the first main demarcation that was done since then, during that time. And particularly, this community was identified, and you can see in the maps, in the old maps. We're not showing those maps here right now. That particular community was even included as Agua Caliente, the full name, in that 1890s map. Now, in 2018, so very recently, the three main agencies in the country that deal with land-related matters, such as survey, titling, and registry, recognized for the first time that there was a huge overlap between a very big mining project area and the lot occupied by 6 of these communities. And so the issues such as the right of indigenous peoples to collectively own the land and use the resources connected with environmental protection because of the harm that mining activities will bring to this community and that particular area, with development finance, something that we're not going to discuss today. Basically, there was a World Bank-funded land administration project taking place in that same part of the country. All of these issues came together in this case. When we presented the case before domestic courts back in 2008, 2009, we were not thinking about development finance, we were not thinking about climate change, we were not thinking about energy transition. Here, 18 years later, we found ourselves with a decision that provides some standards that are very important for anything relating to energy transition. Nickel is one of those minerals that are being sought with lithium for the purpose of building batteries for electric cars. Plus, it also, because it prevented the project from going forward, it brings up issues concerning environmental protection before mining activities. There were also some corruption-related matters that we're going to see some photos about that. Let me keep going. Now, in this particular case, we're going to get through the procedural history later, but in this particular case, we are dealing with a country where the 60% of the population is Maya, mostly Maya. However, the law in the country basically has enormous gaps. There is no legislation that, for example, upholds or recognizes the right of indigenous peoples to hold the land collectively or to use the natural resources, to the point that the protected area law creates protected areas all over the country, disregarding the fact that communities are located in those areas since time immemorial. In the country, there is also no law that recognizes indigenous peoples as such. Nowadays, and it's been the case since this country was created, agrarian laws and policies have been applied to indigenous peoples, and that means basically that indigenous communities, such as this monolingual Maya Quechua community, is recognized as a peasant community. Now, no law, of course, provides any type of regulation on how government agencies should carry out prior consultations with indigenous communities before any decision-making takes place, particularly when projects are going to affect the land and the resources of these communities. The 1962 agrarian law and the 1999 farm law basically creates a land titling program for the purpose of peasant communities' access to legal security going through a procedure where the land is going to be surveyed, titled, and eventually registered. We will see the ultimate result of that, particularly in this case, and how inadequate that land titling procedure is to fully recognize indigenous people's full collective ownership over the lands and the resources. There are some procedural issues in this, procedural rights issues in this case as well, particularly the fact that the mining code with the environmental assessment laws provide no opportunity for indigenous communities to participate in decision-making. By that, I mean they are not asked to provide comments or opposition concerning environmental impact assessments or mining permits that have being considered by the Ministry of Mining and Natural Resources, even though those projects, such as mining projects, are going to take place on their lands, and they may be eventually forcibly relocated from their lands. Because there is no legislation regulating how to consult with communities, currently the government of Guatemala is starting to use municipal law. Basically, there is a municipal code that creates an entity called a Community Development Council per community, and that is just one person assigned by the community that is being used for the purpose of being consulted of any actions that the government may take that may undermine the land and the environment that these communities depend upon, instead of using the community's own self-determined institutions, such as this pro-improvement committee that this community had. We're going to skip some of this because I'm sure you want to hear more about the actual court decision. But something that will call your attention is this particular slide, where you're going to see that neither in the procedure to issue the permit to explore nickel in the lands of this community and other communities, the community was able to participate. No consultation was carried out. When the permit to exploit was issued, also they were not consulted. The permit is still in force it actually was issued in 2006 for a 25-year period. But in 2021, that's about 3 years ago, basically, the government, out of the sudden, because of a decision by the Constitutional Court that is not connected to the facts of this particular case, decided to carry out consultations with the communities about this nickel mining project. In other words, they decided to consult about something that they should have done almost 15 years earlier. Now, in doing so, the government decided not to invite or allow the participation of Rodrigo Todd and the Aguascalientes Pro-Improvement Council. They actually rejected the participation of some of the families of this community whose lands were explored for mining purposes, because in that particular area there was a concentration of nickel. But there was so much corruption in this consultation that, for example, in November 2022, the US Treasury Department sanctioned 3 owners of Solway Investment Group. That's the transnational company based in Switzerland that owns the mining project being carried out by the Guatemalan Nickel Company, because of corruption schemes in several mining projects, but particularly in the Phoenix project. Later, there was a leak of information, particularly from the company, that was accessed by Forbidden Stories and shared with about 65 journalists around the world, that provides basically all the information on how this company was discussing strategies to divide up the communities, to pay bribes to government officials, police officers, and community leaders participating in the consultations. And you can find, if you Google Forbidden Secrets, you will find all the stories there, including the receipts of the payments that were made. Just to tell you that neither the consultation that didn't happen in the past nor the consultation that happened in 2022 were adequate, were not free, were not informed. And so as a result, we ended up with a very strong decision by the court that we will get in a minute. Just to provide you some background about the domestic litigation, this is a case where we sought changes in the law and policy of the country for the purpose of having for the first time a piece of legislation that will recognize indigenous peoples as such, and all the collective rights that they are entitled to according to international human rights law standards, particularly binding decisions from the Inter-American Court of Human Rights. We also wanted to push the court to order the government of Guatemala to create a dedicated land titling procedure for communities, for indigenous communities in the country. And so this particular community, since 1978, entered into the land titling procedure. In 1985, the government of Guatemala issued a provisional title, and around 2000, in 1998, the pages from the registry books where that provisional title was registered were removed. That is something very common in this country. So there was no legal history of the provisional title, and as a result, the land titling agency, according to them, was not in a position to issue the definitive title. Now, when we sued the land titling agency in 2009, we filed basically an amparo lawsuit. An amparo lawsuit is basically a constitutional remedy that provides for the protection of rights that are protected in the national constitution of particularly Latin American countries, and that's the case in Guatemala as well. So we sued the land titling agency because it refused to take actions to replace the stolen pages from the registry books that prevented the agency from issuing the definitive land title. In 2010, the lower court dismissed the lawsuit, and the argument is very ridiculous. The court said that Agua Caliente actually hold a title, but that was not true because the community that was holding a title was another community under the same name, Agua Caliente, but located in a different lot. Well, we don't have right now the map with the 16 lots, but basically on lot 11. So, of course, we appealed the case, the decision, and in 2011, the Constitutional Court of Guatemala ruled in favor of our client, ordering the land titling agency to take all actions to issue the final definitive title. Of course, the government of Guatemala did not comply with the court decision, so we sued again, asking for compliance, and in 2019, the court again ruled in favor, saying that you must take all actions, not only to replace the pages of the registry books that were removed, but also to issue the final title. Now, what happened in the meantime? We sued the country. As you know, the Inter-American Commission on Human Rights is the first stage in the procedure before the Inter-American Human Rights System. It is based here in Washington, D.C., so we filed a petition in 2011. We're going to go very quickly with this, but basically, the procedure ended with a report on the merits of the case, in 2020, stating that the state of Guatemala violated the American Convention on Human Rights, that's the main human rights treaty, and therefore ordered the government of Guatemala to take several actions, including adopting legislative measures to recognize the right of the indigenous communities to their collectively held lands, and so forth. Of course, the government didn't comply, so the commission referred the case to the court in Costa Rica, and that's the second stage in the procedure. You are probably have an idea why it took us about 18 years to get to where we got. Now, here is another very short procedural history. In 2020, we filed what is called a brief with pleadings, arguments, and evidence. That's basically the main brief that attorneys representing human rights victims file with the court once the commission referred the case to the court, where you lay out all the arguments based on the same facts that the commission referred the case to the court on why you believe the government's omissions or actions implied an actual violation of a right protected by the American Convention on Human Rights. In particularly, we were very much focused on the right to property, to the land, and the right to judicial protection and due process of law. Now, in 2022, we had the oral arguments during the pandemic. You see photos of us there wearing masks, and you can access the videos in YouTube about each of these oral arguments, particularly about the cross-examination of the witness and expert witnesses, and then the final oral arguments with very interesting questions from the judges. In 2023, we filed the final written arguments after the hearing took place. And in May of last year, the court issued the final decision on the merits, on the merits, reparations, and cost. And we were notified about this decision in December. So it's pretty new. That graphic in that photo on top of that slide is basically some of the, I love it because it explains how we got to the court from filing the case in Guatemala, then going to the Inter-American Commission, then to the court, and in the meantime, some other actions that we took. But it is actually how one of the teachers, members of this community that speak Spanish, tried to explain with the graphic what I was saying to them with an interpreter, basically, because I don't speak actually. Anyways, let's see what the court decided in this case. That's the building of the court in Costa Rica, and those are the judges that actually decided the case. The court basically decided that the state violated the American Convention on Human Rights. It didn't fulfill the obligation to respect their right to property, their access to information, political rights, legal personality, judicial protection, and due process of law. It also found that there was a lack of legislation in the country connected to the facts of the case that enabled the company with the government agencies to harm the community's land and their own self-determined institutions in all of the consultation procedures that took place in this case. Now, what did the court say about property law and the actual title that was issued to this community in 2019? The court said that the title, the one that results out of the existing land titling procedure, is basically inadequate because it recognizes an individual property right over the land. It's basically recognizing a co-ownership right per member of the communities. Both the 1985 provisional title and this very recent title of 2019 recognize co-ownership, the first one in 1985 to 64 peasants without lands, and then the one in 2019 to 104 peasants again. You see, they're not even able to use the terms indigenous or members of the indigenous community. They use the term peasants. That's how influential agrarian law is in this country. They also said that it was not the land ownership right, because it was transferable to third parties. Each of these members can actually transfer their portion in the property to third parties. It fails to protect the collectively held lands of the community. It also said that it wasn't a title recognizing a pre-existing property right to the land. Instead, it was a title that recognized the right because the community had to fulfill certain conditions and different requirements, including payment of the value of the land. And we're talking about communities that are very poor, very, very poor. And they had to travel to Guatemala City from where they are located. That usually takes about 8 hours driving, and in a very different context from where they are coming from, and in a very different language and so forth, and they have to manage to get money to pay all of these expenses for this land titling procedure, something that doesn't happen in other countries, particularly in Argentina, where I'm from. The 2019 title that was issued to the Agua Caliente in particular was defective because the overlap between the mining project area and the land possessed by this community was not resolved. As a result, the community got a title recognizing co-ownership right to 104 members, and with a problem, which is that they are sitting on a land where the company also holds a mineral rights. We'll skip this one. let's go to the main orders, what actually the court ordered the state of Guatemala to do. And this is something very interesting, very important, because I think we got what we wanted from the very beginning in 2005 when we started to work on this case, because the court ordered Guatemala to issue a new title that will basically recognize for the first time a full collective land ownership of this community. Because the full collective land ownership is not part of Guatemala's legal system, there is no legislation, the court ordered the state of Guatemala to adopt legislative measures to recognize such a new property right for indigenous peoples. And in doing so, they have to carry out a consultation with communities, and not only the Agua Caliente community, but all indigenous peoples of the country. The title, the new title, must recognize the community's permanent use and enjoyment of the land and natural resources. And this is important because right now, under Guatemalan law, the communities have no right whatsoever over the resources pertaining to their lands, to the point that any protected area, for example, can be created on those lands and they will have no say. They will have no participation in decision-making about how to manage those lands. This is very important because one of the main arguments that we brought forward in this case was indigenous peoples' permanent sovereignty over the natural resources. Why are we discriminating about this very big principle of public international law when it comes to indigenous peoples, when human rights law considers them as distinctive legal, social, and political entities? And in this particular case, they depend upon the land and the natural resources for survival. And that's the very same reasons why this general principle of law about permanent sovereignty over natural resources exists in public international law. Now, the state must also consult with Agua Caliente to agree on how decisions by the parties on land titling related matters would be communicated. If you follow me, in 2022, the government carried out this consultation with a lot of corruption, leaders that were paid off, and so forth. And as a result, the community got divided very recently. We have the Community Development Council, and then on the other hand, Rodrigo Todd with the community's Pro-Improvement Committee. And as a result, the court is saying, you now have to consult with both of them, and all of you have to agree on who is going to communicate decisions about this title, and then the other orders that we're going to go and talk a little bit today.
Maybe just wrap it up here quickly, Leo. I want to make sure we at least have time for one question before we get to it.
The court also ordered the state of Guatemala to pass to adopt a new legislation that will provide regulations on how government agencies carry out consultations with indigenous communities, particularly when it comes to mining projects on collectively held indigenous lands. And in that lawmaking process, they have to include the participation of all indigenous peoples of the country, and this is very big. And I think I will leave it there.
Awesome. Thank you so much.